Steve O'Donnell probably wishes he could take back what he said on the witness stand. NASCAR's president just confirmed that NASCAR saw SRX as a threat and took action to protect their dominance. In an antitrust trial, that's the last thing you want to admit. When you're defending yourself against monopoly charges, you never want to say you were scared of competition. But that's exactly what happened on day 4 of this trial. And it gets even messier from there. Judge Kenneth Bell had seen enough. He stopped the proceedings and told NASCAR's attorneys to pick up the pace. This wasn't a polite suggestion. When a federal judge says you're moving too slow, he's really saying he thinks you're stalling on purpose. The judge didn't stop there. He turned to the witnesses and gave them direct orders. Answer the question straight. No more long explanations that avoid the real answer. Just yes or no when possible. In a courtroom, this is the judge's way of saying he won't tolerate games from either side. Think about what this means. The judge is watching every move. He knows when someone is trying to run out the clock or confuse the jury, and he's making it clear that won't fly in his court. Now, here's where things got explosive. Steve O'Donnell took the witness stand. O'Donnell came prepared to defend the charter system. He laid out his argument carefully. Charters started at around $2 million back in 2016. Today, they're selling for over $40 million. That's a 20 times increase in less than 10 years. O'Donnell said this proves the charter system is working great for teams. On paper, that sounds pretty good for NASCAR's case. If charters are worth so much more now, how can teams claim the system is unfair? But here's where the plaintiff's lawyers started digging deeper. They brought up SRX, the Superstar Racing Experience. This is Tony Stewart's short track racing series. It's tiny compared to NASCAR. They run 6 races a year on small tracks. It's more like a fun exhibition series than a serious competitor. But here's what came out in testimony. NASCAR was genuinely worried about SRX. Internal documents showed NASCAR executives discussing SRX as a competitive threat. They were concerned about losing drivers to this little series. The plaintiff's lawyers pounced on this. They asked O'Donnell direct questions. Did NASCAR see SRX as competition? O'Donnell had to admit they did. Did NASCAR take steps to limit driver participation in SRX? The evidence suggested yes. Now think about this from a legal perspective. NASCAR is arguing they're not a monopoly. They say teams have other options. They claim there's plenty of competition in racing. But their own internal documents show they were scared of a 6-race series run by a retired driver. If you're truly confident in your product and you don't have monopoly power, you don't fear tiny competitors. You ignore them. The fact that NASCAR took SRX seriously enough to potentially limit driver participation tells a very different story. It suggests NASCAR knows they have massive power and they're willing to use it to crush even small threats. The lawyers pressed O'Donnell on the charter agreement restrictions. These agreements don't just cover racing in NASCAR. They include clauses about what else teams and drivers can do, where they can compete, what series they can participate in. O'Donnell tried to justify these restrictions. He said they protect NASCAR's brand. He argued that if NASCAR drivers were racing everywhere, it would dilute the product. Fans would get confused. Sponsors might pull out. The restrictions, he claimed, actually help teams by keeping NASCAR special. But the plaintiffs see it differently. They argue these restrictions exist for one reason only: control. NASCAR wants to make sure teams have no alternatives. If you sign a charter agreement, you're locked into NASCAR's system. You can't explore other opportunities without NASCAR's permission. The cross-examination got intense. Lawyers confronted O'Donnell with evidence that teams had no real negotiating power. They showed him documents where teams asked for changes to the charter agreement, and NASCAR said no. They presented testimony from other team owners who said it was take it or leave it. O'Donnell stuck to his position. He insisted teams had input in the process. He said NASCAR listened to feedback, but when pressed for specific examples of changes NASCAR made because teams asked, he struggled to provide clear answers. Then came the moment that might have damaged the plaintiff's case. Bob Jenkins took the stand. Jenkins owns Front Row Motorsports. His team is literally one of the 2 plaintiffs suing NASCAR. He's supposed to be a friendly witness. Jenkins started by describing the problems with the charter system. He talked about how hard it is to make money. He explained how NASCAR forced teams to accept the new agreement or face losing their charters. He painted a picture of a sanctioning body with way too much power. But then NASCAR's lawyers dropped their bombshell question. They asked Jenkins about his attempt to sell Front Row Motorsports to 2311 Racing, the other plaintiff in this case. NASCAR's attorney didn't hold back. If charters are so terrible, why sell? If the system is rigged against teams, why would 2311 want to buy into it? If there's no real value here, why negotiate a sale at all? Jenkins tried to explain. He said wanting to sell doesn't mean the system is fair. He argued that just because charters have market value doesn't mean teams can make money racing. He pointed out that you can sell an asset even if that asset is part of a broken system. But the damage was done. NASCAR's lawyers had created doubt. Juries don't like inconsistency. When someone says a thing is worthless in court but tries to sell that thing for millions of dollars in private, it raises questions about credibility. Here's the thing though. Both sides actually have a point here. Charters do have value. That's undeniable. They sell for tens of millions of dollars. But having a valuable asset doesn't necessarily mean you're making money. Several team owners have admitted publicly they lose money racing in NASCAR. Denny Hamlin, who co-owns 2311 Racing, has said his team isn't profitable. Brad Keselowski, who owns and drives for RFK Racing, has talked about the financial struggles. Even with charters worth $40 million, the actual business of racing doesn't make money for most teams. It's like Jenkins said, you can own an expensive house but still struggle to pay your bills. The asset has value, but the cash flow is negative. So wanting to sell doesn't prove the system is fair. It might actually prove the opposite. Maybe Jenkins wanted out because he was tired of losing money despite owning a $40 million charter. But NASCAR's lawyers successfully planted doubt. And in a trial, doubt can be powerful. If the jury thinks the plaintiffs are exaggerating their problems or being inconsistent, they might not believe the bigger claims about monopoly power and anti-competitive behavior. The charter agreements themselves are fascinating when you look at the details. These contracts include a clause that forces teams to give up their right to sue NASCAR. You have to release NASCAR from legal liability just to get a charter. The agreements also limit where teams can race. You can't just take your car and compete in another series without permission. NASCAR controls what other racing activities you can participate in. For drivers, this means they need approval to race in series like SRX or IndyCar or Formula One. The plaintiffs argue this is classic anti-competitive behavior. You're using your market power to prevent people from exploring alternatives. You're tying up teams and drivers so completely that they can't even test whether other opportunities exist. That's exactly what antitrust laws are designed to stop. NASCAR's defense is that these restrictions serve a legitimate purpose. They say exclusive commitments are normal in sports. NFL players can't play in a competing football league during the season. NBA players can't join rival basketball leagues. Exclusivity protects the value of the product and helps everyone, including the teams. The SRX revelation keeps coming back as the most damaging evidence for NASCAR. Here's why it matters so much. SRX runs 6 races. 6. NASCAR runs 36 Cup Series races plus playoffs. SRX uses old cars on short tracks. NASCAR runs on super speedways and road courses with cutting-edge equipment. SRX pays drivers appearance fees. NASCAR offers multi-million-dollar purses and championships. In other words, SRX shouldn't be a threat at all. It's so small and different that it should be irrelevant to NASCAR. But NASCAR treated it as a serious competitive concern. That only makes sense if NASCAR knows they have monopoly power, and even tiny alternatives could chip away at that power. When you have real competition, you don't fear small players entering the market. Judge Bell's warning takes on new meaning in this context. He wants this trial to move faster. He wants clear answers. Maybe he's already seeing through some of the tactics and wants to get to the truth quicker. Or maybe he's just managing his docket and ensuring a fair trial doesn't drag on forever. Either way, the warning puts pressure on both sides. NASCAR's lawyers can't slow-walk tough questions anymore. The plaintiffs' lawyers need to be ready to move quickly through their case, and witnesses know the judge is watching closely for anyone who tries to dodge questions. This trial is revealing whether the current system can ever work for teams. The testimony so far suggests it can't. Even with charters worth $40 million, teams are struggling.